Is there anything that you want the court to consider?
Yeah, so I've read the recommendation. I think the recommendation is spot on, Judge. I think that it's considerate not only of the circumstances which led to this, but also of the person who is the byproduct of where we're at today. And talking to Jen, I think I would appreciate the court looking at the person who made that decision in that moment. I think that's important. I think you always have to do that. But I also think it's important in this case to think of and consider the person who sits before you today. In that regard, I asked her, and I said, if you could do this over, sometimes this is a dangerous question, but if you could do this over, would you do the same thing? And she says, well, I don't want to say that because it doesn't seem like I'm, sorry about what I did. But at the same time, I probably wouldn't have done some of the things that I'm doing now. This recommendation, Judge, was littered with letters of support. I'm quite sure the court's had a chance to read and review those. I can tell you that in my dealings with Jen, I see a remorseful person. I see someone who has always taken responsibility for this. From the sentencing forward, I think that is indicative of this recommendation that is in this pre-sentence investigation report as well. When this happened, Judge, this is a time in Jennifer's life when she wasn't proud of the decision she made. I think people do and say lots of things that they wish they had back in a breakup situation. I know that she's embarrassed. I know that it's affected her. But from accepting this plea agreement and speaking to this court, and beyond that, her conduct since then, I think speaks volumes about who she is going to become as a result of putting herself in a really tough situation. I know that she's been working on her mental health. I think that is evident. I also know that she's been on bond, has not had any other incidents that I'm aware of while she's been on bond by quite some time, since we've been back here several months, in fact, Judge. So I would ask the court to consider the letters of recommendation. I think, again, the recommendation is appropriate. I would ask the court to follow that. And part of it, too, Judge, is that there's a rather lengthy term of probation, which the court's going to impose. And that is yet another opportunity for Jen to not just tell you who she is, but prove who she's become, and that she isn't the person that at least in this incident, she appeared to be on paper. So I would ask that the court follow the recommendation. Thank you.
Right, Ms. Plumhoff, have you had the opportunity to read the report and discuss it with Mr. Shepard?
I have, Your Honor.
Do you have any additions, corrections, or challenges?
I do not.
Anything that you want to say on your own behalf?
Well, I would like to start by apologizing to Nicholas for the hurt and disruption that I caused him his life. I'm not proud of getting to a point where I would hurt somebody that I loved the way that I did him, for breaking our vows and ruining our marriage. I hurt a lot of people that day, that when I chose to make the decision that I did, I hurt a lot of people. And I am truly embarrassed about that and very sorry. Like he said, I'm not proud of what I did. I am proud of the person that I've become because of these things. Being able to turn my life around and turn to faith and get back on the right track. I've worked really, really hard through my therapy, my group therapy, with my church family, just being able to help the community more, things like that. I don't think that these are things that I would have been doing hadn't something like this happened. As awful as it may sound to say, I feel like me hitting rock bottom is something that needed to happen to become who I am. And I'm truly sorry for all of it.
I think Mr. Swanson had a couple of comments to it. Probably got.
Right.
Thank you. I've talked to Ms. Plumhoff quite a bit as well. She has been acknowledging her actions. She owned her actions, and everything and every person I've talked to so far reference to it. She owned into this court as well. We would point out to the court that Ms. Plumhoff, with her consent, she's giving me the impression to tell her that she's now facing some pretty significant medical conditions. She's facing a treatment for potentially breast cancer at this point, and her next appointment is scheduled for October 28th, and she does that further follow-up care package that is going to be required. So she's asking for consider that. We're looking at sentencing here today and consider not imposing a jail sentence, given those circumstances which are unusual of that recent diagnosis. We have the documentation from her doctor here today. Court wanted that documentation as well. She did receive a lot of amazing recommendations from the community, so we asked the court to consider that and look at sentencing here today.
Right, Ms. Robinson, any additions, corrections, or challenges?
Your Honor, people had OV-19 scored at 10 points. I believe that the conduct here would amount to interfering or attempting to interfere with the administration of justice. My understanding the case law does support that conduct can happen before criminal charges are issued as well. It's not, it has to be a fight. That is the only difference that I saw that I thought needed to be noted.
All right, Mr. Shepherd, Mr. Johnson, want to reply to that?
Sure, Judge. I tend to agree with the scoring that was done, like the Department of Corrections. I see that OV-19 was a 0. I think that's, I wouldn't know why that would change, Your Honor. I certainly understand the question, the context around the question. But from my perspective, I think that the scoring that is appended to the PSI, the recommendation, I think that's a.
All right, well, I look something up on that, and I would turn to you, Mr. Kazal. See the recommendation in the report. Just for 1 day jail, 1 day credit. Is that your recommendation, or is that Lanson's recommendation?
My recommendation was consistent with the agreement, which was a cap at the midpoint of the guidelines, and I recommended 150 days jail.
All right, so the court is going to leave offense variable 19 scored after zero, was looking at the criminal sentencing bench book, and although I do note that there are things that can happen pre-charge that could reflect the assurance of justice, but I didn't find a case that reflected where they're essentially trying to frame someone for a kind of crime would be impacting the ability of the police to investigate a situation. It's not tampering with witnesses. It's not the sort of pre-charge conduct, according to C, that other cases have scored 10 points at. So the court's going to deny that request.
Peter, on the
All right. So with that,
I apologize. Can I make a statement? So, yeah. Your Honor, we would ask that the court follow along with the recommendation, follow along with the plea agreement in this case and allow that plea to stand and sentencing to go forward today. Nicholas Plumhoff is the victim in this case. He is present, but saying he would like to make a statement.
oh, good. Mr. Plummer, would you come forward, please?
Back.
Bring up what podium if there's. Yeah.
All right, Nicholas Plummer, is that correct?
Yes, sir.
All right, what is your opportunity, sir?
So it's been a long time. I've been trying to think what I wanted to say when we finally got to this point. And it's just so much more to me than just like trying to get me in trouble. Over the last 5 years, I have worked so hard to get out of the things that I was doing that would be in prison. And for, going back and spending weeks looking at all the messages that went back and forth and how malicious it was. I had one day and made one bad decision. She did this for weeks and weeks. I've read the messages. And for her to say the only thing he cares about is this job at the recovery center, and I want to take it from him. I worked so hard to get away from my background, to have a job where I could help people and make a difference and not be another statistic and not end up back in prison or on the streets. And to just think that someone that said they loved me to just say, or even, I could see her saying it, but weeks and weeks of pushing it, messaging him, well, she was at my house, now's the time to do it. I know where his car's at now. Like, I don't understand. I know what it's like to need to get incarcerated. If I wouldn't have went to prison, I wouldn't be where I am. I wouldn't have taken the time to get the help that I needed, And I don't think one day in jail is ever going to stop her from doing this to someone else. If it wouldn't have happened the way it would, I might not be here right now. I might be back in prison. I might have ruined my career. I might have lost everything, and no one would have believed me.
Yes, yeah.
If it wasn't for the one that turned in the messages, if it hadn't been documented, no one would have ever known, and I would have been gone. And it's not fair. It's not right that to just try to take someone's life in your hands and throw it away because you had a bad day. I would understand if I treated her poorly, if I put my hands on her, if I was mean to the children, none of that effort. And to have someone just want to hurt me like that, I can't imagine being that broken of a soul to want to hurt someone that bad. The worst part is I don't hate her. I just want her to get help. For her, for the kids, for whoever she comes in contact in the future. Because the person that she's not where she needs to be. One thing that I guess it probably doesn't matter because it wasn't reported, but just not even a month ago, she was at a restaurant and ran into my niece and threatened to beat her ass in the middle of the restaurant with her children there, with in front of everybody. So whatever gains and progress that she's made, she's not where she needs to be yet. And I hope that you guys can help her do that.
Well, a couple of questions, please, sir. How did you meet Ms. Plummer?
We met through my little sister. They were acquaintances.
Okay. I only have limited police report. How do you know how Ms. Plummer came in contact with like the person that was incarcerated that she wanted to set you up? You don't see that individual?
The way it was explained to me is when me and her got together, she was in a relationship with that person. And when me and her made it official or whatever, she broke it off with him because he's in prison. What is he going to do? You know, all she has to do is not answer the phone. So that was her boyfriend, I guess, up until I had got with her.
Okay. Anything else that you want to say, sir?
I just want to thank the court for whatever it is they're going to do. And hopefully I'll have a peace of mind for a little while because obviously I'm a mess. Like I literally moved 3 hours away. Did not have to worry about running into her at a store or anywhere, kidding me, because of, I don't know. I worked in Nuevo for a little while in one of the recovery centers that was up here, and going through a drive-through, I had a girl let me know that she was still trying to mess with me and that this was my number and this is where I lived. And so I just don't want to have to worry anymore. I'm a grown man. I shouldn't be crying over what this woman could do to me.
Thank you, sir. All right, the court recognizes that the advisory guidelines in this case would suggest a sentence between 0 and 11 months. The courts can exercise my discretion. It's consistent with the advisory guidelines, consistent with the agreement in this case. Would be the sentence the court, this defendant served 120 days in the Nuevo County Jail. I'll give her credit for the 1 day that she served so far. I'm going to place her on probation for 2 years. There is a $30 per month probation oversight fee for regular probation, $60 a month for electronic monitoring work tether. On the one hand, I applaud you for the efforts that you've made. Well, maybe those efforts will continue after you're out of jail with your probation, and they'll help you change the person that you are. On the other hand, I can't think of anything more vile than what you would try to do to that man. Number one, the newest history with addictions, and to try and use that against him. Number two, trying to prevent him from helping other people, trying to engage some other inmate to ruin this man's life. And he's right. If you had any idea how many people come in here with possession of drugs and say, they weren't mine, somebody planted on me, everybody, the police, prosecutor, court, we all go, yeah, right. People just don't plant drugs on other people. And that was your plan, as he indicated. It wasn't just a fly-by-night thing, one time, call somebody up, oh no, forget it. It was time after time, and message after message. You actually paid the money, as I understand it, to have this done it. I just can't, really words don't express how vile those acts are. And you try to separate the acts from the person, but you're the one that did those. And luckily, this person that you were corresponding with in jail had integrity and did the right thing and turned you in. But for that, he probably would have been in jail. He probably would have been successful in training. And that's it, excuse me. I don't care how much you hurt you. So
What we just witnessed was one of the most difficult sentencing hearings a judge can face, a collision between accountability, rehabilitation, and public safety. On one side, you had a defendant who openly admitted her guilt, detailed years of substance abuse, untreated trauma, and serious mental health diagnoses. On the other, a criminal record that simply could not be ignored. 10 DWI offenses, multiple prior prison sentences, revoked probations, and repeated relapses after earlier opportunities. Let's break down what mattered most legally in this courtroom. First, the charge itself. This was driving while intoxicated, third or more, enhanced by prior felony convictions. That enhancement elevated the case to a second-degree felony, exposing the defendant to 2 to 20 years in prison. Importantly, the state waived habitual offender status, which could have resulted in a sentence of 25 years to life. That waiver alone significantly reduced the maximum exposure and was already a substantial concession by the prosecution. The defense's argument was built almost entirely around rehabilitation. Catherine Welch completed a 90-day inpatient treatment program, followed by nearly a year of trauma-focused outpatient care. She maintained sobriety, complied with monitoring, attended and demonstrated, at least on paper, sustained effort to change. Her attorney emphasized that this wasn't a short-term fix, but years of work aimed at addressing the underlying trauma driving her addiction. And to be clear, the judge acknowledged all of that. He recognized the progress, he recognized the effort. He even stated that his goal was not to undo any improvement she had made. But sentencing is not only about the defendant. The judge repeatedly returned to one unavoidable reality: public safety. 10 DWIs is not a statistic, it's a pattern that placed countless people at risk over decades. As the judge stated bluntly, the community was lucky that no one had been killed. That statement wasn't hyperbole, it was a legal acknowledgement of risk. From the court's perspective, probation had already failed multiple times. Parole had failed. Prior prison sentences of 10 and 15 years had not stopped the behavior. While the recent rehabilitation was real, the judge had to decide whether he could, in good conscience, place the public back at risk yet again. That's where the final ruling came down. The court sentenced Catherine Welch to 18 years in the Texas Department of Criminal Justice, with credit for time served. This sentence fell below the maximum allowed, reflecting some consideration of her progress, but firmly rejected probation as an option. The judge also issued firearm prohibitions, confirmed the plea waiver, and formally closed the case. This case raises difficult but necessary questions, and this is where we turn it over to you. Should long-term rehabilitation outweigh an extensive criminal history? At what point does public safety override personal transformation? And if someone truly changes, how many chances is society obligated to give? There are no easy answers here. What is clear is that this judge viewed his responsibility not just through compassion, but through the lens of community protection and precedent. Whether you agree with the sentence or not, this ruling reflects a hard legal truth. Past behavior carries weight, even when change appears genuine. Now we want to hear from you. Do you think the judge made the right call, or should rehabilitation have been given one final chance? Drop your thoughts in the comments and let's talk about it. And if you found this case as shocking as we did, make sure to hit that like button, share this breakdown, and don't forget to subscribe for more in-depth, no-nonsense courtroom analysis. We'll see you in the next case.